So thanks a million for attending this session today. I'm aware it's the very last one, so as Michael said, well done for hanging in there and staying with us. My name's Jenny Dolan and I'm an Assistant Commissioner at the Irish Data Protection Commission, and I head up our Children's Policy function. So I'm really delighted to be here to take you through our approach to children's data processing, and it was great hearing from our UK colleagues in the previous session about all the work that they're doing in this space. So I think it ties in nicely in terms of giving us the opportunity to just give you some insights in terms of what the DPC is doing in this area. There is an awful lot of overlap. I was raging that I'm going second and Michael gave you all the insights first, but we'll jump through any of the overlap. So the primary focus of today's session is on the DPC's fundamentals, and that's a detailed piece of guidance on children's data processing that we published at the end of 2021. And this followed 3 years of research and 3 separate public consultations. So just in terms of the structure of today's presentation, I'll just start by giving you a little background, as to why we went about creating this guidance and how we did it. And then we'll move on to the nuts and bolts of the fundamentals. So the type of standards that we set out, and the impact of the fundamentals on the issue of age assurance, which is why we're all here today and why we've gathered for this summit. So, as many of you know, the DPC are the lead supervisory authority for data protection in Europe for very many of the global technology companies and internet platforms that have their European headquarters in Ireland. And many of these organisations offer online services where children represent a substantial cohort of the user population. So the protection of children's data in the digital sphere is really an intrinsic part of the DPC's regulation of these companies. And we've also identified the prioritisation of the protection of children and other vulnerable groups as one of the 5 key pillars of our regulatory strategy for 2022 to 2027. So it's very much an area that we're determined to drive higher standards of data protection. So why did we decide to publish guidance on this topic? Well, it all started, I suppose, in early 2018 in the run-up to the implementation of the GDPR, when we first began exploring the area of children's data protection rights. And the reason for this was because the GDPR was the very first EU data protection law to devote special attention to the processing of children's personal data and indeed the position of children as data subjects in their own right. And Recital 38 is really at the heart of this new focus on children. And it states that children merit specific protection with regard to their personal data because they may be less aware of the risks, consequences and safeguards involved, and they may also be less aware of their rights. But because the GDPR is a principles-based law, as we all know, questions began cropping up inevitably about how a number of these provisions, and I think Anna mentioned earlier, there's about 25 different references to children and child in the GDPR, how these should actually be implemented and interpreted in practice. So as part of the DPC's obligation under Article 57 of the GDPR to promote awareness and understanding, particularly activities addressed to children, we decided to begin the development of a detailed research-based piece of guidance on issues affecting children. And this should be used by organisations as essentially a roadmap for their processing activities. So we decided to run a public consultation first and foremost to gather the views of all relevant stakeholders. But most importantly, we wanted to give children and young people the opportunity to have their voices heard on matters in relation to this, because they have a right under Article 12 of the UN Convention on the Rights of the Child to have their voices heard on matters that affect them. So our consultation was divided into 2 streams. Stream 1 was launched in December 2018 and targeted more traditional stakeholders like industry, parents, educators, children's rights groups, that kind of thing. And we invited them to respond to a number of questions set out on a traditional consultation document. We then launched Stream 2 on International Data Protection Day in 2019, and that process sought to involve children and young people directly in the classroom through a specially designed lesson plan and consultation process, and this was aimed at children aged 8 and up. So in order to do this, we created and designed a pack of lesson plan materials, and we reached out to every single primary and post-primary school in Ireland, as well as all youth reach centres, and invited them to take part. We also created a quick start guide to data protection for teachers, just acknowledging that there might be a bit of a knowledge gap there. And we also created a promotional video featuring our former Commissioner, Helen Dixon, just to explain the consultation process and what exactly it was we were asking of schools and of students. So the lesson plan had a really strong focus on social media because we wanted to make sure that the materials actually resonated with children and reflected their reality rather than talking about, data protection in an abstract context. So it was based around a fictitious app that the DPC created for educational purposes called SquadShare, which was just an app for sharing photos and videos and chatting with friends. And it was through learning about SquadShare in the context of these lessons, really, that children were introduced to data protection issues. They were informed of their rights under the GDPR. And then we asked them to record their opinions on various questions at the end of the lesson on feedback posters provided by the DPC. But in full acknowledgement of the fact that we aren't teachers, we're certainly not experts in creating lesson plans. We actually demoed these lesson plan materials with the help of the Irish Ombudsman for Children's Office in a series of pilot workshops in October 2018. And we were really lucky enough to work with some fantastic young people from 3 different schools between the ages of about 10 and 17. And it was an absolutely fantastic experience. And I'd really strongly recommend to any organisations here who are, project planning and their projects involve children, involve kids in your co-creation process, in your decision-making process, because it was certainly a real eye-opener for the DPC in terms of their level of understanding, but also in terms of the feedback that we got from kids as to what was working and what wasn't working. So it was fantastic. And if anyone's interested in hearing about all the wonderful things the children had to say, we actually published a report on this stream of the consultation, and it collates all of the really insightful contributions that they had to make. So we used the feedback then from both streams to commence what we now call the fundamentals. They were published in draft form at the end of 2020 for a final public consultation, just to give people the final chance to have their say on the standards that we were proposing. So the final version was then published at the end of 2021. And this marked a real milestone for the DPC because it was a culmination of intensive work in this area over 3 years, involving 3 separate stakeholder consultation processes, a lot of engagement with experts in the field of children's rights, expansive research, and a 2-stage drafting process. So moving on now to the actual contents of the fundamentals, which consists of 14 child-specific data protection standards that we expect all organisations to adhere to when they're processing children's personal data. And these standards derive from the high-level obligations set out under the GDPR. So much like Michael mentioned earlier with the Children's Code, the fundamentals are basically the prism through which we examine the application of the GDPR as it pertains to children. And importantly, the guidance is firmly anchored on the principle of the best interests of the child, again, much like the ICO's code. And this is a really common thread that's interwoven throughout each of the 14 standards. In terms of scope, the fundamentals apply to any organisation processing children's personal data, so not just online, offline as well. And they apply to services that are directed at, intended for, or likely to be accessed by children. And I know Michael went into a good bit of detail on this, but just to say that the DPC found this a very important distinction to make as well, because in our experience, we were finding that websites or apps were often just saying, oh, our services aren't intended for children, or they're not intended for children under a certain age, when in actual fact, they had millions of users under those, age thresholds. And they were very much aware of it. And I think that was the kicker as well. It wasn't as if they weren't aware of this. So it's the DPC's position really that organisations cannot hide behind their intended audiences. They have to go that extra mile in terms of protecting children who are in reality using their service. So you can see from the screen here that the fundamentals cover a number of different areas. So from transparency, the exercise of rights, profiling, DPIAs. And there's no hierarchy or prioritisation really of any of these principles because they each address different but equally critical areas of the GDPR and how it applies to children. At the same time, I suppose when you're talking about planning from the ground up as an organisation that will process children's data, then of course you need to start with the basics. So those gateway issues that will enable you to put in place the building blocks, so to speak, for compliance across all areas. So we would see the standards around knowing your audience and being able to identify children where you have a mixed user service as really central to being able to meet that higher standard of protection that the GDPR requires controllers to take. And I suppose if we had to identify one overarching theme really that ties together all of the core principles of the fundamentals, it would probably be age assurance. Because I suppose if you think about it, if you need to be able to ensure that you have appropriate transparency information in place that children can easily understand, then you need to know who your audience is and that you're dealing with children. You know, likewise, if you need to avoid profiling children for the purposes of targeted advertising, then you need to know which of your users are under the age of 18. And in order to bake in that higher level of data protection by design and default into your service for child users, so for example, setting default account settings to private or turning off geolocation by default for child users, then you need to know that you're dealing with children. But all of that said, you've probably spotted the first principle at the top of the list there, the floor of protection, and you might be wondering what that means. Although after Michael's presentation, you're probably not. So the fundamentals set out the position that when it comes to data processing, organisations should either treat all users as children by default or take a risk-based approach to age assurance. So if an organisation feels they cannot achieve a level of efficacy for age assurance that's proportionate to the risks posed to children by its processing activities, then it must implement a floor of protection for all its users. So that essentially means applying all of the principles to all users, because that's really the only way to ensure then that children benefit from that higher standard of protection that the GDPR requires. And again, this is an approach mirrored in the ICO's code. So the way we see it really, effective age assurance or alternatively adopting that baseline floor of protection for all users is really the key gateway for compliance with the DPC's fundamentals. But as Michael alluded to earlier, I think it's really important to highlight that this floor of protection principle only applies when we're talking about age assurance for the purposes of GDPR compliance. And it does not apply for the purposes of child online safety. So applying that forward protection and treating all user data as though it belonged to children, it's not going to be sufficient for organisations whose services are illegal for children to access or indeed pose serious risks and threats to children. Now, the DPC acknowledges that there are different scenarios in which organisations might need to use age assurance. And again, Anna touched on this earlier in her presentation. So the first is in the context of Article 8, which is the so-called Age of Digital Consent. So as we all know, this stipulates that in the context of information society services, where processing is based on consent, children can only give their own consent where they are over the relevant age of digital consent in that member state. And the GDPR offers discretion to member states to set this between 13 and 16. So for example, in Ireland, the digital age of consent is set at 16. So if an organisation is relying on consent in Ireland to process children's personal data, they cannot obtain consent from a child under the age of 16. And they have to make reasonable efforts to ensure that consent has been given by the holder of parental responsibility. But I mean, if we think of this kind of in practical terms, in order to get to a point where an organisation can verify that a parent has given consent, they need to know first that they're dealing with a child. So again, while the GDPR doesn't contain an explicit reference to age verification, it's often a practical implication of Article 8. So age assurance or age verification will also be required in contexts where access to adult-only services like porn or gambling needs to be restricted to adults only, or to prevent access to certain types of content that's harmful to children. So, for example, content depicting gratuitous violence. And finally, and perhaps the trickiest use case, is where organisations need to use age assurance to provide a child-friendly version of a service which attracts a mixed user audience. So in other words, offering those enhanced data protection settings and features for child users. And this approach of, really baking in that kind of high level of data protection by design and default across the service is another key principle of the DPC's fundamentals. And it's one that requires organisations to know the age of its users. And the bake it in principle, I suppose, is really about default account and privacy settings and features, as well as safeguards, and making sure that protection measures are built into the architecture and the functioning of a product. So this takes in the best interests of the child principle, and it also takes into account the evolving capacities of a child in terms of what appropriate default settings might look like, what features are available to adult users that are not safe or appropriate from a data protection perspective. And to help organisations comply with this, the DPC has identified a non-exhaustive list of recommended measures, which you can see here on the screen. And these range from things like ensuring the strictest privacy settings, turning off geolocation by default for children where it's not in their best interests, right up to avoiding the use of nudge techniques that might encourage or incentivise children to engage in privacy disrupting actions or to provide too much information. So we've seen that there are a number of different scenarios whereby age assurance might be required. And I think we can all agree that there's no one-size-fits-all solution. Appropriate age assurance mechanisms are likely to vary from context to context. It'll depend on factors such as the service being provided, the sensitivity of the personal data being processed. But in any event, the DPC's position is that age assurance measures should be proportionate and grounded on a risk-based approach. So that means there should be greater stringency or levels of certainty provided by the particular verification process where the processing of personal data undertaken by the organisation is of higher risk to the user. Now, in practice, it's likely that some products or services might need to rely on a combination of age verification methods in order to assure the most effective approach. And the methods that are appropriate for organisations, again, will likely vary from context to context considerably. But I suppose whatever the combination of methods deployed, the result must be demonstrably robust and effective, and it must achieve a level of reliability that's commensurate with the risks posed by the processing in question. And I suppose the concept of a risk-based approach is not novel under the GDPR. It's very much baked into it. So as with the processing of any personal data, when you're taking a risk-based approach to age assurance, this means assessing the risks to the rights and freedoms of individuals that might arise as a result of the processing of your data, and implementing appropriate and proportionate technical and organisational measures to mitigate these risks. But I'd also say that taking a risk-based approach really requires companies to take an honest, hard look at their processing activities and implement meaningful mitigating measures on foot of this assessment. So in our fundamentals, we provide a non-exhaustive list of minimum criteria that organisations should take into account when they're adopting a risk-based approach to age assurance. So this involves looking at things like the type of personal data being processed. So are we dealing with health information? Are we dealing with images, videos, information about sexual orientation? Likewise, the sensitivity of said personal data needs to play a role as well. So are we dealing with special category personal data or even data that could be considered sensitive for other reasons like financial information? The type of service being offered to a child is also very important to take into account. Are we dealing with an app, video or image hosting platform, or apps that facilitate making connections with strangers, for example? Also, the accessibility of personal data collected to other people. So whether the nature of the service is to publish or make available to the world at large the personal data of children. And finally, the further processing of personal data, including whether data collected is shared with other organisations and the reasons for doing so. So these are just some examples of the criteria that the DPC sets out. As I mentioned, it's a non-exhaustive list, but it's really the kind of starting point for organisations when they're taking that risk-based approach. But that said, regardless of the purpose for which age assurance mechanisms are being used, they all must comply with the principles of data protection set out under Article 5. And Michael has gone through this in quite a bit of detail, so I won't labour over the points. But your processing needs to be lawful. If you're processing personal data for the purposes of age assurance, you have to have a legal basis therefore. The processing needs to be fair. So, users shouldn't be confused by the fact that you're using this personal data. It needs to be done in a way that they would reasonably expect. Transparency, we had a really rich discussion about this earlier, and the importance of being very upfront with users in terms of how you're using their personal data for age assurance. And I think another important point around that is the fact that you need to make it clear that users have the option to challenge a decision that might be made on the basis of the processing of their personal data for age assurance purposes. And then, of course, purpose limitations, so they mustn't keep the data for any other purposes. They must only collect the minimum amount of user data. it's imperative that the data collected for age assurance is accurate, because if it's inaccurate, it could lead to incorrectly flagging a child as an adult, or incorrectly flagging an adult as a child. Obviously, the personal data collected for age assurance must be deleted once the appropriate level of confidence as to the user's age has been attained. And obviously, any personal data collected for the purposes of age assurance must be kept secure. And accountability then, of course, which ties together all of these previously mentioned principles. So it's been just over 2 years since the fundamentals were published and took effect, and we've moved into implementation phase now, as opposed to awareness raising phase, which was where we were for the first 2 years. So in the past year, we've actively engaged with a number of controllers in the multinational tech space, in particular on many issues relating to children's data. And we've done this primarily through our supervision function, which is a really important part of the DPC's regulatory toolkit, because as well as supporting organisations and driving compliance, it enables the DPC to proactively identify potential problems before they occur, and ensure best practice is applied at project planning stages. So we have seen some positive changes in recent times as a result of engagement with these controllers against the backdrop of our fundamentals. Changes in terms of default privacy settings. We're also seeing more consideration being given upfront in DPIAs to the potential harms specific to children that may arise from the processing of personal data in a specific context. Though I will say there's still a lot of room for improvement in this regard, particularly in terms of providing, I suppose, further evidence in terms of the efficacy of the mitigating measures that are being proposed in order to mitigate against these risks. More recently, we've witnessed some efforts by certain controllers to improve transparency to child users, with some trying kind of more innovative ways to provide bite-sized pieces of information via videos and things like that. But I think there's still a long way to go in that respect, and we touched on that again during the panel this morning. It's not just bringing it down to the level of simplicity of language. I think a lot needs to be done in terms of the look and feel of both privacy policies and just-in-time notifications throughout the user journey. So I don't think we've reached a stage where children realise that this information is actually being directed to them. All of that said, supervisory engagement isn't the only tool that we use to examine data protection concerns as they relate to children. So sometimes enforcement action is required. And this was apparent through the 2 large-scale inquiries into children's data that the DPC recently carried out. One into Instagram, which was finalised in September 2022, and the other into TikTok, which was finalised in September last year. And these inquiries focused on the area of transparency, data protection by design and default, data protection impact assessments, and age assurance. And together, and I mentioned this earlier, the administrative fines imposed on foot of these inquiries amounted to €750 million. And this represents a really sizable chunk of the fines that have been handed out by the DPC to date. So I think it's quite telling in terms of the importance that the DPC is placing on the protection of children's personal data, and also what the cost of getting this wrong looks like. So we are currently assessing more targeted ways to tackle specific issues of concern under the fundamentals. And we're going to be working on a roadmap for the coming year. But I think it's clear to say from both our supervisory engagement and the inquiries that we've carried out to date that the key areas of focus for us really are on transparency, data protection by design and default, DPIAs and age assurance. So this will likely dictate, I suppose, the direction of travel for the DPC in terms of where we focus our efforts for the coming months and years. So that's been a bit of a whistle-stop tour of the DPC's fundamentals. I've also popped up some useful links in terms of links to our lesson plans, reports on the various feedback from our different consultations, as well as a link to our final version of the fundamentals. So thank you very much for your attention.
We've got a few minutes for questions before we all head off to the pub or our hotels or wherever. Yeah.
Thanks, Jennifer. Just really interested in the research around children's voice, and that was one of the first topics I went to this morning. Mark Bentley did a fantastic presentation about children's voices. So just so I can clarify, you asked the children and then disseminated, or did you disseminate and then data collect. What was the part of the children's voices?
Yeah, no problem. So what we did was we sent out the lesson plans to all schools, enabled them to learn about data protection, because if we just sent out a series of questions without giving any kind of background information or education on data protection itself, I don't think they would have been in a position to necessarily answer. And we sent out feedback posters. So on each feedback poster, there was a specific question pertaining to the various areas under the GDPR that merit special protection in the context of children. And we just tried to gauge their feedback in relation to those specific areas. So it focused on things like the age at which they can exercise their own rights without parental involvement, what they thought of advertising and their use of their personal data for the purposes of profiling. Spoiler alert, the main word that came back was creepy and scary. So it was through means like that we got their feedback, and that fed into then the development of the fundamentals. Because for taking example, the exercise of children's rights, you'll be aware that there's no law in Ireland that stipulates an age at which a child can exercise their own rights, be it in data protection or any other context. So I think that you can see the feedback throughout the fundamentals. It really permeates the voice of the child throughout the various standards that we have provided. But there is a report dedicated to that if you'd be interested in reading it.
Absolutely. Sorry, just a quick follow-up. So you gathered that data, it was anonymous.
Oh, apologies. Yeah, if that was your question. Yeah, but it was done on a class-by-class basis, I should say.
Yeah.
So there was no personal data collected from children at all.
And did you
we should highlight
have a
that.
view of what the parents thought of that, or?
In terms of whether the parents were happy for them to be, well, there was a note sent out through all schools, and it was up to the schools of whether they wanted to participate or not. But there was no personal data gathered in terms of what came back to us. It was just a series.
In terms of what you were talking about, did parents have a voice in that as well?
They didn't. Well, that was stream one of our consultation, which they would have been very welcome to submit responses on. We did hear from certain teachers that they had sent the lesson plans home with the students and encouraged them to bring up the discussions with their families and things like that at home. But no, stream two was predominantly aimed at children in the classroom, but obviously parents had the opportunity to engage in stream one of the consultation as well.
Thanks, Jenny. We've got a question online. Why was the fundamentals not a code of conduct?
Well, so that's where it differs in terms of the role of the ICO's code. The ICO has statutory underpinning to create a code, whereas the DPC does not have that statutory underpinning. So it is a code, but it is a guidance note, I should say. But as I mentioned earlier, it's really the prism through which we examine the application of the GDPR, which, as Michael said, is the law. So I think that's probably sufficient from our perspective.
I'm just curious, did TikTok and Instagram actually pay up the 750 million?
Yes, directly to me. No, no,
Or did they appeal?
Both decisions are under appeal at the moment.
So they haven't actually...
Not as yet, because they're under appeal.
And I suppose my second question then is, having been found in breach, what changes, if any, have they made? Because I'm obviously, you can guess from my accent. It's us Corkig, me. But I'm meeting kids 5-6 years of age that have TikTok accounts, that have, so what measures are the platforms making in Ireland, if we're looking at this, to make sure that kids aren't on the platform?
Yeah, no, so I should say, in addition to the administrative fines that were imposed, both inquiries also had compliance orders built in addition to the administrative fines. As far as I'm aware, the compliance orders in relation to the TikTok inquiry are still being examined in terms of whether, what stage they're at in terms of bringing the processing into compliance. The Instagram, there was a specific business account scenario whereby those accounts were set to public by default. That's no longer the case. So there are a number of measures that have been implemented as a result.
Great, thank you so much, Jenny.
Thank you.